thank Matthew, who has been here all week, dutifully ensuring that we can actually be heard. Well, I hope we're heard. Yeah. I thought that my job this evening in some ways is to try to pull together the 4 talks that you've had. And so I wanted to start off, if I may, just trying to sketch the map as I saw it of, and in the question time, people may say that I've forgotten things or misrepresented things or what have you, and you're very welcome to let me know. But here's what I took from this week, in which I thought that all 4 of these presentations, one way or another, raised a whole series of profound points. Remember, the framing of what we were talking about is 20 years of the Constitution, which basically, the final Constitution was signed in December 1996, and we've just gone past the 20 years. And I'm conscious of what Penny Andrews said when she opened our sessions, that 20 years is not a long time in the history of a country. It's not a long time in the sense of looking back and trying to find some concrete set of analyses. But I do think there are issues that each of our speakers touched on, which are extraordinarily important. Before I do that, may I just sort of say this about the backdrop. We started this enterprise 20 years ago. And 20 years ago, just over 20 years ago, Professor Frank Michelman, a very distinguished professor of law at Harvard Law School, came out to our country together with a group of people to a seminar that we organized. I say we, being a group of us, when I was at an institution called the Center for Applied Legal Studies at the University of Witwatersrand. And I'm delighted that Professor Heinz Klug, now from Wisconsin, is in the audience just serendipitously, because he was around in about that time too. And Professor Michelman came with a group of American academics to talk to the Constitutional Court, which had just been appointed. The seminar took place in, I think, 94 or 95. The court had not yet, maybe 94, because the court had not yet actually delivered its first judgment. And so you can imagine the situation, the group of academic lawyers from the United States of America, all, I should say, of the progressive bent, who came out to South Africa to engage with our newly appointed Constitutional Court judges and others about what this Constitution meant. And Professor Michelman gave a talk, which you can find, if you're interested, in the 1995 South African Journal of Human Rights. And I actually commend it to everybody. It's a remarkable piece, and I've taught it often over the last few years, because it seems to me such an extraordinarily insightful set of remarks by someone who had never been to South Africa and was talking to judges from what I suppose in the Rawlsian idea would be the original position, meaning judges who had not given one judgment yet. And the quote I wanted to introduce my talk from Michelman's article is the following. He's talking about the South African Bill of Rights and compared to his own, the American Bill of Rights. I hasten to add that he's talking in the 90s, during the time of Clinton, somewhat different situation to the con man who now inhabits the White House as we speak. But what he said was this: it seems to me that your Bill of Rights may be meant much more strongly than ours to serve as an opening towards a fundamentally reconceived society, a signpost along the road towards a revolutionized future, a future still to be charted, and charted in part through the process of law. That is, in part through constitutional adjudication that progressively instills concrete meaning into abstract right statements, with a view to realizing in actuality, in the lives of people, in the still and for some time yet to come unfolding condition of a new South African nation. It's an extraordinarily, in my view, profound statement. Let's unpack the statement, if I may. What he's saying is that the Bill of Rights, the South African Bill of Rights, which essentially is what we've been talking about, although I'm going to go talk some of the other issues that Deputy Chief Justice Moseneke raised last night with you. He was talking about this idea that the Constitution in general and the Bill of Rights in particular saw as its function the reconception of our society. That the Bill of Rights was a signpost, a journey, if you wish, which we had to take towards a revolutionized future. And mind those words, revolutionized future. That means a future totally different from the one which we inhabited when we began the constitutional enterprise. Let me pause here to put parenthesis and just to ask you to think about it. Can we really say that we've moved very progressively along a path towards a revolutionized future? And I leave that for your own consideration. Come back to it, if I may. He then says, it's a future which has to be charted, meaning the Bill of Rights can't give you the answers alone. Abstract statements of rights contained in a document can't possibly just tell you offhand, well, that's what's going to happen. But what it did say was it was a future which we had to chart for ourselves, and in part it was going to be done through law. And as Michel Leroux said on Tuesday night, quite correctly, as apartheid itself had been charted through law, here we were going to revolutionize our own society through a process of law, of course the very antithesis of that which had dominated the vicissitudes of South African society for almost 300 years. And then he says further that what has to partly be done is a process of adjudication that progressively installs concrete meaning into abstract right statements. In other words, the idea, the function of the judges, if I put it that way, is in a sense to take that document that Justice Yaqub invited you to read carefully and make of those abstract statements something that was real in the lives of ordinary people. And that in a sense that conceptualization of the future of the country would be one which would take time. It was still, and for some time, to be unfolded. It was to develop a new South African nation. And I want to come back to that idea as well, of the new South African nation. So in a way, this short quote from this remarkable introductory speech by Professor Michelman is, as it were, the signpost for my own presentation this evening and my attempt to pull together the four splendid presentations that you've heard to date. So let me, without further ado, and with the prism of that particular idea, just touch on issues which have been canvassed over the past 4 days. Dean Andrews spoke on Monday night, among many things, but the thing that I wanted to pick up upon was her emphasis on equality. She was quite right, of course, to point to the questions of gender equality, because it is a remarkable feature of South African life, is it not, that somehow we talk a lot about race, and rightly so, but we don't talk too much about gender. So somehow women, that's another thing. It's sort of, well, rather put on the side. But I think what she meant when she was talking about equality, and let's take the question of gender, and let's take the question of race, because she spoke about that too, is in a sense the idea that this constitutional instrument, if it was going to work, really was talking about a fundamental change in the structure of our society. And you can't have a fundamental change in the structure of a society when the Gini coefficient, which measures income inequality, is arguably as bad as it was now as it was during the apartheid era, absent, I accept, the tax and transfer system, which has helped to some extent, and we can talk about that in question time if you so wish. But the truth about it is that when she was talking about these questions, it seemed to me that what was actually being highlighted here was that if you look at changing the structure of South African society, given that race, class, and gender are so intertwined, we really have done far too little about that in terms of a society which was supposed to chart its course. Zach Yacoub, Justice Yacoub, spoke a lot about identity. You may recall that in his presentation, he was talking to some considerable extent about the way in which we are still so divided in our own country, on racial lines, on gender lines, on class lines. And what he was, I think, referring to a large extent, again, reflects back on Professor Michelman's comment of 20 years ago, was that this constitution had to be seen to be a challenge to change the very nature of what it meant to be South African, of what it actually meant to be part of a newly conceived nation, not one of them and us, not one where some of us sort of say, well, you see, what do you expect from them? Of course, them is never quite defined, save a few penny sparrow. But the truth about it is that those sorts of issues, those issues about how do we come to terms with our history of racism, of sexism, how do we come to terms with a society in which we are so divided, how do we reconceive ourselves as a new nation, is, I think, to some extent, what Justice Yacoub was talking about, and rightly so. I'll come back to one or two of the other comments, but I wanted just to move a little bit to some of the comments that the Deputy Chief Justice spoke about last night. The failure of constitutional design. That's another issue we have to think through. We designed the Constitution, it seemed to me, let me say, as somebody who was there at the constitutional drafting session, we drafted a Constitution in which the sort of subliminal, and maybe not just subliminal remark was, well, Mr. Mandela would never do that. In other words, you can't be serious, that he would in fact do X, Y, or Z, and therefore it was okay to draft the Constitution in the way in which it was actually conceived. So we, in a sense, gave the president all sorts of powers. And then we suddenly discovered that actually Mr. Mandela was mortal and somebody was going to take over from him. And the question was that you design constitutions not for individuals, but you design them, in a sense, for your future in the longer sense of that word. And we have found that to a large degree, all sorts of powers given to the president really are very problematic. Let me give you one illustration because it's close to my own heart. The Commission of Inland Revenue was actually appointed at one point in time by the Minister of Finance. And for some reason, which is truly an ironic point of history, Mr. Manuel, who was then the Minister of Finance, and a very good one too, I might add, and Mr. Gordon, who was in the Commission of Inland Revenue and was an equally good Commissioner of Inland Revenue, somehow got into their heads that they wanted to give the Commission of Inland Revenue more powers, make the Commissioner more independent. And it was something which we, who were on the CATS Commission of Inquiry a few years earlier, and so far as tax were concerned, would worry about. So what they did was, and of course, the president at the time was President Mbeki, and I know there's lots of criticism about him, but one of the criticisms you can't have about him was that he didn't have a fairly acute idea about the question of the economy. I mean, he really did understand. I mean, I didn't agree with his policies about the economy, that's not the point. So the idea was, well, the president will appoint the commissioner. And so suddenly the minister and the Commission of Inland Revenue got together, the law was changed, And as a result, the Commissioner of Inland Revenue was no longer appointed by the Minister of Finance, but by the President. Well, move along 9 years now. Now we can't get rid of the Commissioner of Inland Revenue unless the President does so, because as we know in law, he or she who appoints also has the power to dismiss. So those of you who read your newspapers will know that there's an extraordinary impasse between the Commissioner of Inland Revenue and the Minister of Finance, which is not exactly good news for a country which requires taxation for very fundamental redistributive purposes. And what do? We kind of didn't look at this institutionally and say, what's the best process? Many countries don't just give an unfettered discretion to the President or the Minister. They've got a whole range of bodies which in a sense have an input into these processes, but we didn't do that. And those examples are manifold in terms of the fact that we constructed a constitution which to a large degree gave excessive powers to one person. I suspect that the United States of America might begin to have that same debate quite soon if you followed the last week. But my problem is South Africa, not America. Secondly, the structure between the legislature and the executive was a problematic issue. We kind of have the strange system in South Africa where we have the legislature structured in a fashion with the executive, which is a kind of hybrid system between what we used to have under the Westminster parliamentary system and a proper split between the legislature and the executive, meaning that we appoint a president from effectively the ruling party. There's no direct election of the president. And you may want to ask another question. Assuming if we had direct election of the president today, would the president be in office? Right? And what would that say? So what we got a legislature which the majority party appoints the president and then, in a sense, is beholden to both the president and to the party officials within the party. By the way, not just the majority party, the minority party as well. I mean, if we want to say, you're going to take a big risk if you contradict what the president says, I suspect certainly when Helen Zille was the leader, you take a big risk if you actually criticized her. And probably that may still be true with Mr. Maimane, even though he seems to be a more avuncular individual. But what I'm simply suggesting is that the party bosses had a huge role in this. So then when we're surprised by the idea that Parliament doesn't hold the executive accountable, perhaps we shouldn't be so surprised, because the internal structure militates against that process. You're hardly likely to actually start saying, no, Mr. President, you've got to pay the money back. It's a sort of career-limiting move if you're in the majority party. So I'm suggesting to you that there was a structural fault in our design. I'm not sure we could have, of course, the question is what would have been a better thing, we can debate that too. But I'm simply pointing out a problem that was highlighted during these lectures, and rightly so, which is to what extent does the legislature hold the executive accountable, and to what extent, therefore, is the doctrine of separation of powers for a country like South Africa, which has a very thick constitution with many rights and socio-economic rights and commitments to substantive equality, what kind of doctrine of separation of powers can sustain itself when in fact that delicate balance between the legislature and the executive is rendered as difficult as I suspect our one is? And that, of course, raises the point that was made particularly by Michel Leroux on Tuesday night, which is the concept of lawfare. The idea that if you don't have a legislature that actually does the job, then you rush to the courts all the time. So consider the following. If you had a legislative scheme where the legislative the members of our parliament really felt emboldened, I suspect that when the Public Works debate came before Parliament and they saw the budget for Nkandla, there would have been a hell of a brouhaha and a holding accountable all sorts of people, including the President, and saying, what on earth's going on here? How come this 250 million rand is being spent on swimming pools and other strange accoutrements, right, at Nkandla? That would have happened. Mr. Motsoeneng would not have troubled me and all my colleagues incessantly. Right? And trust me, it's an experience I don't want to repeat, having him in my court for 3 days, whilst this whole issue unfolded. Because you think about it, there are actually lots of people who really need litigation. Poor people. And you have to spend your time worrying about Mr. Motsoeneng and his shenanigans. That would have been dealt properly by a parliamentary process. You will say it's starting to happen now. Maybe. And we'll come back to that in a moment. But all I'm suggesting to you is that the structural faults which I'm pointing to have had consequences whereby the pressure is put on the judiciary. And when Michelle Leroux listed all those cases that, in fact, she classified, I think, correctly as lawfare cases, there was quite a significant sort of couple people in the audience said, gee, that's an extraordinarily long list. And the answer is it is. And you ask yourself, why? Well, I'm telling you one of the reasons why. And so that's a particular problem. There's a third issue which I wanted to touch on in relation to the structural questions. I know that the Deputy Chief Justice, with his customary acuity, would have dealt with more of these and did deal with more of these. But the other one I wanted to highlight was, of course, the Judicial Service Commission. You see, actually, the Judicial Service Commission was a really good idea. And the idea of the Judicial Service Commission, which I think, if my memory serves, was partly borrowed from all sorts of various models, including the German idea that the upper house of the German legislature has a role, and Americans and so forth. So we had this idea, quite rightly, that you did not want the Minister of Justice to appoint judges. You may remember that was the way the apartheid regime worked, right? Judges were appointed through the minister, as he was called affectionately. And the minister appointed basically, occasionally you got some good judges because they needed commercial judges. And that's how I suspect judges Didcot and Goldstone and Gerald Friedman and a whole lot of others who I'm probably not forgetting, but we can list quite a number of other judges. They were all there, Solly Miller, they were all there because they had been appointed for commercial expertise, but of course you couldn't just preclude them from working for other cases. But the fact matters, we did want to have a more independent system. We didn't want the kind of situation where the famous remark of Tilman Roos, who actually, strangely enough, did find himself eventually on the appellate division in the 1930s, but was a Minister of Justice in the early National Party regime, and who said famously, when a whole lot of judges were appointed, he said, we appointed these people because they were sort of members of the party. Now they think they're there on merit. And so we didn't want that sort of thinking. So the idea was to have the Judicial Service Commission. And the Judicial Service Commission was designed, as it were, to ensure that a broad spectrum of society would have input into the appointment of judges. And so what happened, unfortunately, and it worked quite well to start with, because I go back to the Mandela point. You see, for some damn reason, we said that the president could appoint 4 people. Well, in the first thing, Mr. Mandela appointed people like George Bezos, Gamotsa Morocco, and John Ernsten, who was a trade unionist. I can't remember the 4th one was, but there were 4 people who were really drawn from the spectrum of South African society and who acted in the most principial possible way. But because there's a structural fault in the design, there's now no guarantee that the president doesn't appoint 4 of his own. And if you took those 4 together with, as it were, the Minister of Justice, as was hinted both by Justice Yaqub and Motsoeneng, and you take those, the Minister of Justice, together with the representation that the ruling party has, they've got a majority. So we're almost back to where we were, which is what we didn't want, you see. And it's now become a very difficult body, an unwieldy body. There are far too many people, and it's not an easy body to manage. which is why Chief Justices do have a difficulty in managing it, and it is a body which has made some astoundingly inconsistent decisions. So, we all know a few. Jeff Budlender, who I think most people would think is the best judge we've never had. There was Hilton Cheadle, our colleague at the University of Cape Town, who was regarded as not even good enough for the High Court as well, as Jeff. Jeremy Gauntlet, QC, who's applied millions of times and good enough to become a QC in England, but not to be a judge even of the High Court in South Africa. We had Clive Plaskett, an outstanding administrative lawyer, who somehow didn't get onto the Appellative Supreme Court of Appeal, which really bemused everybody. And now we had the most oddest of all. I'm not suggesting that the others weren't all pernicious or bad non-appointments, but this one really bemused many of us. So G.M. Malindi, who is a silk at the Johannesburg bar, right? And obviously from the name, it's black, and I say that for a particular reason. You would have thought that for a High Court appointment in Gauteng, you'd want a black silk. Gosh, that's fantastic. Here's somebody who's actually learnt their stripes. They're a proper silk at the Johannesburg bar. They're making themselves available. Fabulous. Why doesn't he get on? Oh, because he's too close to the ANC. See, scratch your head and say, sorry, but this was a man who was a UDF treason trialist, right? Who really I know well and has done a very fine job when he's been acting on the Labour Court, has always behaved, as anybody who knows him, with a great deal of principle. And suddenly now he's too political. So one day you have people who say you can't appoint them because they've got no struggle record. Then the next day you've got people who say there's too much of a struggle record. And so the inconsistencies of the appointment of judges is another structural question in which I think we made a mistake. May I just make one other structural point? I know that there are many people who suggest, and it's come up in discussion, that the property clause was a mistake and we shouldn't have had one. Now, I was one of the people who thought we shouldn't have a property clause. I should tell you that, quite frankly. Canada doesn't have a property clause, and there are other constitutions that don't have one, but we did get one. And we got it with a lot of agonizing debate one way or another. And if you read the property clause, that clause never prohibited the government of this country from addressing land questions. And Justice Yacoub reminded you on Wednesday night that it took 20 years for this government to pass an expropriation bill which might well meet the demands of land. I mention this not to make a cheap political point, but to simply say, I don't think that's a structural flaw, yet it is used by many as a reason for the fact that this constitution retards progress. And that brings me, therefore, to the question of whether this constitution actually retards progress. Professor Meyerowitz correctly suggested in the quote that I gave you, that the Bill of Rights really at root is simply a series of abstract right statements that have to be given concrete meaning. And therefore, if you ask yourself, does that text prohibit a reconstitution of South African society into this revolutionized future that he was talking about, I want to suggest to you that it doesn't. Now, there were a lot of comments, starting with Professor Andrews, Dean Andrews on Monday night, again rightly so, and stretching through Michel Leroux and Justice Yacoub's remarks about the question of the conservative nature of the legal profession, and perhaps, may I say, of our legal education, where in this very room I often have to struggle rather desperately towards the end to do what I call repair work amongst a whole lot of students who've just haven't swallowed a lot of doctrine and have no, what I suppose C. Wright Mills would call a sociological imagination, or to put it more bluntly, an understanding of what Professor Meyerowitz was saying in the quotation to which I referred you. Now, those have effects, because when the profession reproduces that level of conservative nature, when you've got judges appointed through the JSC who may not, in fact, embrace a normative framework as Professor Meyerowitz has suggested, or as Justice Yacoub said, when I was quite interested in that figure. You may remember that he said on Wednesday night that in the old days, only 1 or 2% of the judges would have had anything other than a formal textual adherence to the law, i.e., he said there were only 1 or 2% who would have kind of saw that the question of law and justice were not distant cousins that only met occasionally, but actually were inextricably linked the one with the other. The point that I wanted to make was that he then said that he thought that probably 30, maybe 35% of judges today were in that category. And he's probably right, but that's quite low if you think it through. If the demands are as I'm suggesting them to be. And that really then puts demands on our legal profession, on our faculties, etc., etc. And so what I'm really saying is that in some ways our constitutional enterprise has suffered from some considerable defects, structural as I've set them out, and I think as well analytic in this sense of an inability to actually do what Meyerowitz suggested, which was to see the Constitution not as just another piece of law, but as an opening towards a fundamentally revolutionized future. And that requires judges, lawyers, and the public at large to understand that this Constitution does provide us with the promise to constitute a new South African nation. That it does not constitute an obstacle, far from it, from a society on which substantive equality is taken seriously, where land reform is implemented expeditiously, where private power is rendered accountable in a serious and meaningful way, and where, in a sense, therefore, governance, both public governance and private governance of power, is central to our enterprise. None of those are precluded from this text. What you've seen until in the 4 lectures that we've had is that we have not produced the questions of equality, which Professor Andrews opened our sessions with. I don't think that we've embraced a conception of identity, and we need to talk about that. You see, the strange thing about this whole debate about decolonization is if we could start having a debate about what it means to be South African in a fashion that we can transcend the real divisions of the past in a way which actually allows us to be open about why we've not done that and how we should and how the Constitution should do it and how the courts should actually start talking in this particular fashion, then we get somewhere. I was struck the other day, to give you an example. I was facilitating a session on 20 years in the Constitution. The people, the Secretariat, who'd helped us so wonderfully to sit in Parliament and draft the final Constitution, decided that on the December, whenever it was, we were going to have a panel conversation about the 20 years of the Constitution, and all sorts of drafters from all sorts of political parties arrived, including Corné Mulder from the Freedom Front Plus. And let me say this, I know we're an odd society, because whenever I listen to Dr. Mulder, he always makes a lot of sense, you know, and I think like, well, we have such different political views, but somewhere along the line I realized as I was listening to him why we actually did get that settlement in a strange way, that there were some people who understood that they could go beyond their own, and there was Tony Leon from the Democratic Alliance, we had Ibrahim Patel from the ANC, Sheila Kamara at that stage, who was a National Party Deputy Minister of Justice, and there were other people as well. And a young man put up his hand and asked a question. And I won't say who answered it because I think that sort of embarrass the person given what I'm going to say. But the question was asked about this. Did the Constitutional Court really embrace African values in a holistic fashion? Did it, as it were, develop, if it was going to be so concerned with South African identity, did it develop a jurisprudence over 20 years? Or can we see a jurisprudence developed over the 20 years, which, in a sense, moves us away from nodding vigorously in the direction of Germany, Canada, less to the United States of America, less to Britain, and some way to the European Court of Human Rights, and more to our own indigenous value system. Justice Lecoub made the point on Wednesday night that Ubuntu should have been there, wasn't there, but we could still use it. He's quite right. But the question was, to what extent have we embraced that? To what extent does our constitution represent this idea of a new nation? That everybody can say, well, we can start seeing why we're getting there. And the question was asked, well, don't you think that hasn't happened? And the particular individual answered, said, well, you know, the Constitutional Court's given quite a number of judgments. It found a judgment that a woman could be a chief rather than the man. It gave a judgment which suggested that male primogeniture was not necessarily determinative of intestate succession. That's true, it did. And rattled off a few further cases. And it struck me as the answer was given, that what that was that sort of like almost, you know, going into the departmental store where, you know, ground floor Eurocentric jurisprudence, basement African jurisprudence, instead of a fusion. Instead of sort of saying, actually what the question was about was how do we fuse these different systems into a new kind of set of conceptions, which in a sense then represent a new form of identity and in turn a signpost to a new South African society. And I think at best, some of the debates we've been having at present are about that. The question is how to take that energy away from the irrationality and focus it on the kind of serious engagement, and that's a difficult question. But I simply mention it to you, and I think it would be wrong of me not to do so, insofar as looking at 20 years of constitutionalism is concerned. So where does that leave us now? I think there's one thing that's clear to me, that, number one, we're going to have to address fundamentally a couple of serious challenges. The first one is this question that you can't run a vibrant political system through lawfare exclusively. You can't, in other words, expect the judges to solve all the political turmoil in the society. One has to be able to conceive of some political set of mechanisms which are vibrant, have legitimacy, and can work. Judges can hold the line. They can create space for that activity to take place. But I think at the end of the day that one has to think beyond the ideas of law. And maybe judges have got to start thinking about what a nuanced conception of separation of powers is, in a sense, to promote a further development of that debate. I also think that, as I've tried to indicate this evening, I think we do have to be honest about the structural flaws. I've mentioned some, I've picked up some of the Deputy Chief Justice's remarks, and he was right to do so. I think we also have to, quite obviously, pick up the challenges that Professor Andrews raised with regard to questions of equality, both gender and race. And all of that comes to a further point, which is the point that we are in a case now where there is a counter-narrative, and we should not be naive about it. There is a counter-narrative that this constitution is Eurocentric, that it's there to basically retard the progress of black people, that in a sense it's there to preserve white privilege, and it has to be completely and utterly rendered asunder. I've tried to indicate to you that nothing can be further from the truth if we take the enterprise seriously, but we've also got to take the discourse seriously. There's a comprador class in this country which is using that narrative for its own perfidious ends. And if you're a constitutionalist, you've got to take seriously the challenges that we've been talking about in terms of a politics which in a sense is a proper form of, I think, constitutional politics, which does see that what it's all about is this signpost towards a revolutionized future. And to what extent, therefore, in conclusion, do I think that there are some possibilities here? Well, I do think, and I pick up on some of the points that Michelle Leroux made in her lecture, which I think are correct. I do think that there is a reawakening of certain elements of civil society. We've got things like the Save South Africa campaign, not that they're entirely unproblematic for all sorts of reasons that we can talk about if you wish. We've got at least some trade unions which have now started to talk rather more forcibly about various questions. There are other forms of civil society which have shown a level of vibrance that perhaps wasn't there some years ago. I think the fact that students are protesting in some ways may be a bad thing on one side, because I actually do like to lecture without sort of fearing that I've got to run for my life. But I also think that the idea that we have students who no longer think that the central feature of academic life is to get a BMW or a Mercedes-Benz when they're finished, and that there's something rather more important in life, I think that's really encouraging. So the question is how we deal with that, and I'm not discouraged by those features. I think that there is a level of political contestation now that is perfectly obvious to anybody, which goes way beyond the question of just the minority parties, but within the ruling party as well. And whilst I think, as Michelle rightly said, there's certain of the press that have been captured, I mean, sadly, we don't have a proper newspaper in Cape Town anymore, although I suspect the Burger may be one, but, you know, for all sorts of historical reasons, I find that incredibly difficult to say. I mean, they ran a campaign against me in the 1980s, which sort of, you know, is most unpleasant. But the fact of the matter is, we still have a range of media, which is not necessarily traditional media, who are saying things. We are able to access information, not just the alternative facts, but actual information that is taking place. And the challenge, therefore, it seems to me, because Justice Yacoub made the point, and I want to end with this, when he said that this is not just about judges, it's not just about lawyers, it is about all of us. And the real challenge is how we frame that discourse. Can we actually pick up the challenge that Meyerowitz posed 20-odd years ago and frame the discourse in that way? That in fact there is serious work to be done if this country is going to in any way vindicate the vision of that constitution. Because if we don't do so, then in 20 years' time, you know, if we have another, or 10 years' time, if we have another session like this, we'll all be ruining the lost opportunities. So the threats are there. But I also think at the same time there are possibilities which lurk behind those threats, all of which point in the direction that we should be taking, as opposed to the one which some would like us to take, and to the lost opportunities, both in terms of our jurisprudence and in terms of our structure, which have been part of the journey of the past 20 years. Is that surprising? No. This was never going to be an easy process. It was never going to be an easy process to transcend 300 years of egregious racist law. But the fact is that unless we actually embrace the kind of vision which I suspect I've been trying to talk about, which my co-lecturers this week have been trying to talk about, then we will be in very serious trouble. So I'm going to end there because I've gone far too long, and I'd like very much for you to make any comments, questions, observations that you so wish. The floor is open. Thank you. Yes, please. Part of the problem is the discourse, you said. Sorry. Judges like me get deaf very quickly. So, yeah.
The quality of debate in Parliament
yes.
taken by the major parties because of the list system.
Yeah.
Surely we'd have a far healthier debate in Parliament if there was direct representation.
You mean a constituency-based system?
Yes.
Well, it's a very interesting question. I didn't talk about that, but you're right. That, you know, some years ago, late Van Zyl Slabbert chaired a commission of inquiry into the idea as to whether, in fact, the electoral system that we have at present was suitable for a democratic society as our own. And he came up with the idea of multiple member constituencies, which was the notion that you kind of combine the best of proportional representation with the idea of people actually having some level of direct accountability to those who elected them. And it's a great pity that that report has just collected dust, because it was the basis, I think, for us to have a very serious conversation about these particular questions. And you did right. I mean, the parliamentary, not just the parliamentary debate, but I mean, you know, you listen to the stuff that's on the radio. I mean, between some of the people who actually run these programs, I don't want to mention some of my pet hates who cause me to almost have an accident almost every day when I'm unfortunate enough to hear them. But I mean, we really have a pathetic discourse on one level, and that's ironic, because on another level, we're a very politically literate society. And I'm not talking about educationally literate, but I'm often, because of the television program I do, I'm often fascinated by having conversations with ordinary sort of people who say, oh, I know you were on television, and I'm always intrigued. So I say, have you watched? Oh, yes, and what was last week? They tell me. Then they start telling me why I got it all wrong. And these are people who may be petrol pump attendants or shop attendants or just people passing the street, cleaners at the airport. We make a very terrible mistake. We've got a very literate, politically literate population. If we only listen to them, and they don't get listened to by anybody, which is why we have huge amount of delivery protests and all that sort of stuff. And it is about the listening and about the promoting of the discourse. You're quite right. And certainly in Parliament, I think that if you had a more direct form of representation, I think it would concentrate the mind. Yes, I do agree with you. Yeah, that must be the national security establishment. Other questions? Yes, please. Oh, yes.
And I don't know, I'm very concerned often by what I read on that Facebook page and what is posted by others of his followers. There's a lot of what that I agree with. A lot of the concepts they raise, I have a lot of sympathy for. But my sense is that, and I realize it's a small group of people. Well, he has 3,000 followers. I don't know to what extent they will agree with him. It's almost too late in some respects. Anything that comes from a Western perspective is completely dismissed.
Yeah.
And I don't know how we're going to fix it.
Well, you know, I don't want to talk about him because I think he's a student here. Yeah. What I prefer, yeah, but the principal basis of your question, which is about this question of the Westernized, you know, the idea that everything comes from the West is terrible. I think we've got to realize a number of things. Firstly, I do think that for many students at our universities, well, let me go back a moment. I've got to say this because otherwise I'll be misconstrued. So let me say, until the present dean arrived at my law school, I used to complain to previous deans about the following. Every year, I used to go to an event called Students for Law and Social Justice. And they had a conference in Onrust at the Habonim Jewish Socialist camp of all places, where normally you'd get about 300-400 law students from all over the country, demographically representative, so about 85% of them would be black students. And I say this because it really was a most remarkable event. There were many things that were remarkable about it, including the fact that the late Chief Justice Arthur Schaskell used to come every year. And I really just thought, you know, his contributions was just extraordinary. No Chief Justice in the world I can think of would have actually come along for 2 days and sat with students, put up with their abuse, engaged with them seriously. It was fantastic. But every year, we used to have this thing called the sort of campfire discussion, in which the Chief Justice was participant. And for about 3 or 4 years in a row, many of my black students afterwards from UCT would come to me, and the line of complaint would be the following. If we come from a Model C school and speak English, as my father, who used to comment about, since I'm Jewish, would talk about the sort of people who came from Eastern Europe who spoke mit accent. What he meant by that was, in this particular case, that if you were from the township schools and you spoke with a township accent, you felt that you were never taken, they felt they weren't taken seriously. They felt that in a sense they were looked down upon, talked down upon, that everything about them was second rate, and they felt that the discourse of their lecturers and the way in which things were being presented to them was insulting and demeaning, and they felt disempowered. It is true that to some extent the ones who came from Model C schools felt differently because, frankly, they spoke without that accent, and many of them, the English was better than many of the students from other race groups. But I'm saying this happened every year, and I'm raising this with you for the simple point that it's come home to roost. We did not listen. One of the problems about anger is you think, gosh, why are they so angry? Well, that's partly because for years and years and years, people don't take them seriously. And yes, of course, you then get an excessive anger. And younger people generally tend, I know that's a long time ago since I was young, and I'm looking at some of you, the same with you. But the fact of the matter is, once upon a time, we were all young. And once upon a time, we all probably took extreme positions one way or the other. Well, that's part of the problem. So when I read this stuff, I say to myself, I'm not so worried about what they've done wrong. I'm rather worried about what we've done wrong. And that doesn't mean that I'm going to sort of accept everything that is said. It's outrageous to have to insult my dean in the way she's had to suffer. I'm talking about the present one. Or the vice-chancellor of this university in the way that he's had to suffer. Or any of that. That's just not acceptable. But what worries me is how do we engage with the pathology which is underlying that. And part of what I've been trying to talk about this evening is is in a sense addressing that question, which is to sort of be reflective about what it was that was intended from this journey that we were supposed to start 20 years ago, and why is it that we've communicated so badly to so many. Now, I think with middle-class black children come to the university, I bet you that many of them have still got members of their extended family who are living in not much better conditions than in fact was the case under apartheid. And there's also, and we need to be honest about this, an incredible anger which is displaced to the university, I accept, by the ineptitude of our political system, which has failed to deliver on the promises that I've been seeking to outline. So these are complex questions. And what does give me hope is that out of that anger, I've just got to accept that somewhere along the line, and we know that those of us who teach here, that there are more than enough students who, if you can get by this process, and we have to, we can start engaging with the kind of points that I've been trying to make. So, yes, of course there's that anger. And of course there's a lot of the stuff that is all westernized. Some of that's a narrative that I've tried to suggest to you comes from a particular vantage point of total expedience, opportunism, and I can assure you has absolutely nothing to do with the question of the egalitarian vision that I've been trying to develop this evening. But there's the other side as well. It's the best I can do to answer what is a very difficult, and thank you very much for a very important question. We've still got some time. Yes, please. Hello, Cora.
Ignorant and perhaps racist question. Is there a capital jurisprudence? Where does it come from?
There is certainly, there are a number of things. There's certainly a massive body of customary law. There are values. There are communal values, which are less individualistic than ours, in which the community is placed first and the individual is placed second. It gives content to questions of what equality means and what liberty means and what dignity means. There are practices, frankly, I'm not an anthropologist myself, but I've been very persuaded by my friends Jean and John Komaroff, the Harvard anthropologists, they're South African, who talk about the fact that this is a living process of law. And its truly problem is that it's our ignorance in in looking at that law seriously in terms of the values. I'm not so worried about, if you're going to say to me, well, in a global society, you've got to have a contract that, meets certain standards. That's true. But even then, we have real debates about, does freedom of contract actually give way to a concept of good faith? Now, where do we get that from? And what kind of values do we quarry down to have a South African concept of good faith that actually engages with the question of freedom of contract at the same time? Those are the sorts of issues that I think it's a question of not having an apartheid vision, meaning that you've got that side and that side, trying to embrace an idea that the abstract rights of that constitution in particular are fueled by a normative framework which actually takes seriously the value system of the society at large. And that's a hard job, but it's a hard job in all sorts of ways. It goes back to the point about what kind of judges do you want and what kind of lawyers do you train and how do you do that. But if you don't do that, we can't pretend, for goodness sake, that we're sitting there. There was that great photograph. There was a great cartoonist, a sort of predecessor to Zapiro, David Meyerowitz. For those of you old enough like me will know he was the Cape Times cartoonist. And he used to draw, we may remember, Verwoerd with the telephone going up to God. And he had this one cartoon which always stuck in my mind, which was like, he had a cartoon of Africa. Verwoerd was showing his cabinet Africa, but the map showed that South Africa was cut off and it was put as part of Europe, you see, and the caption was, you see, we're not part of Africa. Right? And the simple point I'm making is that you can't have a system in which you engage almost exclusively with what the Canadians say and what the Europeans say. You've got to ask yourself, if those abstract rights have content, how do they gain legitimacy unless you start quarrying down to see what value system of your society is actually there? Yes, of course, but I mean, there are all sorts of... Look, there's been a massive failure in the academic side of things because as a judge, what we rely on to a large degree is what is produced by counsel, and that includes, not that they're particularly good at that. Very often you've got to actually say to them, Yaqub said, I think, on Wednesday night, rightly so, very often it's only when they get to the highest court and then they've lost all the way, then suddenly desperately, as a last desperate attempt to save their reputation, they rely on some incoherent constitutional point, like that Australian film, but we look at the vibe. That's the best they can do. But actually, when you look at the academic community, one of the things that you'd expect from them, which has not happened, is precisely that kind of engagement, that sort of thing of saying, so where the counsel can get up and say, Judge, let me refer to the following, in which there's some serious engagement with these particular issues. There's a poverty of imagination in the academic community, I'm sorry to say. I'm part of it myself. So, I'm equally guilty, but I'm saying it's that sort of, so you did right. And, I was struck very early on when I was actually a counsel in one of the Constitutional Court cases in which it was weird because issues of customary law came up. And, the whole case was bizarre. You could have used Louis Buñuel would have made a really surrealistic film about this because the two counsel were myself and Gilbert Marcus. So these two overweight Jews are kind of arguing with the judges. Turns out that none of the judges, even the black ones or the white ones, or the two of us, knew anything about customary law. One of them did, Justice Mahoro, and the rest of us were pretty clueless. There we were floundering around. I thought to myself, this is insane. Maybe I, coming from my background, have got some excuse, but we should be having judges who are deeply steeped in these issues as well, and probably my own fault for not having, done enough research to actually answer the questions that were put to me. And that's why you've got this dichotomous jurisprudence, and that's why the question of the young man who asked, somebody who really does have some influence, or used to have influence, the question, and why that question is such an important one. It still remains so. Sorry, yes, please. I'll come back to you, Corin, but yeah.
During the apartheid
Well, that's a good question. In the problem about, when I'm talking about the law, the African customary law is certainly part of our law, and it operates right through in many traditional communities. There's a big dispute about that because there are bills now, to thank Matthew, who has been here all week, dutifully ensuring that we can actually be heard. Well, I hope we're heard. Yeah. I thought that my job this evening in some ways is to try to pull together the 4 talks that you've had. And so I wanted to start off, if I may, just trying to sketch the map as I saw it of, and in the question time, people may say that I've forgotten things or misrepresented things or what have you, and you're very welcome to let me know. But here's what I took from this week, in which I thought that all 4 of these presentations, one way or another, raised a whole series of profound points. Remember, the framing of what we were talking about is 20 years of the Constitution, which basically, the final Constitution was signed in December 1996, and we've just gone past the 20 years. And I'm conscious of what Penny Andrews said when she opened our sessions, that 20 years is not a long time in the history of a country. It's not a long time in the sense of looking back and trying to find some concrete set of analyses. But I do think there are issues that each of our speakers touched on, which are extraordinarily important. Before I do that, may I just sort of say this about the backdrop? New South African nation. It's an extraordinarily, in my view, profound statement. Just unpack the statement, if I may. What he's saying is that the Bill of Rights, the South African Bill of Rights, which essentially is what we've been talking about, although I'm going to go talk some of the other issues that Deputy Chief Justice Moseneke raised last night with you. He was talking about this idea that the Constitution in general and the Bill of Rights in particular saw as its function the reconception of our society. That the Bill of Rights was a signpost, a journey, if you wish, which we had to take towards a revolutionized future. And mind those words, revolutionized future. That means a future totally different from the one which we inhabited when we began the constitutional enterprise. Let me pause here to put parenthesis and just to ask you to think about it. Can we really say that we've moved very progressively along a path towards a revolutionized future? And I leave that for your own consideration. Come back to it, if I may. He then says, it's a future which has to be charted, meaning the Bill of Rights can't give you the answers alone. Abstract statements of rights contained in a document can't possibly just tell you offhand, well, that's what's going to happen. But what it did say was it was a future which we had to chart for ourselves, and in part it was going to be done through law. And as Michel Leroux said on Tuesday night, quite correctly, as apartheid itself had been charted through law, here we were going to revolutionize our own society through a process of law, of course, the very antithesis of that which had dominated the vicissitudes of South African society for almost 300 years. And then he says further that what has to partly be done is a process of adjudication that progressively installs concrete meaning into abstract right statements. In other words, the idea, the function of the judges, if I put it that way, is in a sense to take that document that Justice Yaqub invited you to read carefully and make of those abstract statements something that was real in the lives of ordinary people. And that in a sense that conceptualization of the future of the country would be one which would take time. It was still and for some time to be unfolded. It was to develop a new South African nation. And I want to come back to that idea as well, of the new South African nation. So in a way, this short quote from this remarkable introductory speech by a few years, because it seems to me such an extraordinarily insightful set of remarks by someone who had never been to South Africa and was talking to judges from what I suppose in the Rawlsian idea would be the original position, meaning judges who had not given one judgment yet. And the quote I wanted to introduce my talk from Meyerowitz article is the following. He's talking about the South African Bill of Rights and compared to his own, the American Bill of Rights. I hasten to add that he's talking in the 90s, during the time of Clinton, somewhat different situation to the con man who now inhabits the White House as we speak. But what he said was this: it seems to me that your Bill of Rights may be meant much more strongly than ours to serve as an opening towards a fundamentally reconceived society, a signpost along the road towards a revolutionized future, a future still to be charted, and charted in part through the process of law. That is, in part through constitutional adjudication that progressively instills concrete meaning into abstract right statements, with a view to realizing in actuality, in the lives of people, in the still and for some time yet to come, unfolding condition of an... We started this enterprise 20 years ago, and 20 years ago, just over 20 years ago, Professor Frank Michelman, a very distinguished professor of law at Harvard Law School, came out to our country together with a group of people to a seminar that we organized, I say we, being a group of us, when I was at an institution called the Center for Applied Legal Studies at the University of Witwatersrand. And I'm delighted that Professor Heinz Klug, now from Wisconsin, is in the audience just serendipitously because he was around in about that time too. And Professor Michelman came with a group of American academics to talk to the Constitutional Court, which had just been appointed. The seminar took place in, I think, 94 or 95. The court had not yet... maybe 94, because the court had not yet actually delivered its first judgment. And so you can imagine the situation of a group of academic lawyers from the United States of America, all I should say of the progressive bent, who came out to South Africa to engage with our newly appointed Constitutional Court judges and others about what this Constitution meant. And Professor Michelman gave a talk which you can find, if you're interested, in the 1995 South African Journal of Human Rights. And I actually commend it to everybody. It's a remarkable piece, and I've taught it often over the last